Welcome back to Courtroom Authority, where real justice meets raw emotion. Today's case is one that spirals from fear to defiance to a judge's final breaking point. Meet Maris Hankey, a 22-year-old with no prior record. Until now. What started as a bond violation hearing quickly turns into a lesson about accountability and second chances. His attorney pleads that Hankey simply panicked, cutting off his court-ordered GPS tether out of fear of going to prison. But here's where things get messy. Prosecutors reveal secret jail calls, hidden victim contact, and a shocking connection to an AR-15 threat. Will the judge show mercy or make an example out of him? Watch closely, because this hearing exposes what happens when fear meets defiance inside a courtroom that doesn't play games. What do you think? Should a scared first-time offender get another shot? Or does cutting your tether cross the line? Let us know in the comments below before the judge delivers his verdict.
Workhouse case, People versus Marquise Hankey.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Attorney Kevin Bassant, P71061, on behalf of Mr. Marquise Hankey. Mr. Hankey, state your name for the record.
My name is Marquise Hankey.
All right. And Judge, we're asking for an adjournment. I just got substituted into this matter yesterday, Your Honor, and we're asking for an adjournment for discovery.
That's fine, appropriate.
Adjourned the matter March 13th, 2025, 9 a.m. Yes, that's about.
Your Honor, I'm not sure, is the court in receipt of the bond violation report?
I am not.
I have not reviewed it either, Judge, but I'm certain what it would say. But
Your Honor, I have a report from February 24th of 2025 that the defendant had absconded from his tether and had been unable to be located. And they stopped supervision. I also wanted to address his jail before he got out.
Do we have that?
No, we do not.
And you're aware of this?
I am, Judge.
And Your Honor, I also wanted to address his jail calls from before he was released.
Yes, go ahead.
In those calls, the defendant contacts a third party who then contacts the victim. The defendant says, I need you to do me a favor. So you have that number right, and the person says, whose number? He does, who is the victim. He says, I can't say the name. He says, whose number? He does, who is the victim. He says, I can't say the name. I can't tell the name, but I need you to do me a solid. He said, okay, what? Tell them I'm thinking of you. And he says, the defendant says, y'all been talking, right? He says, no, I've only been talking to Peter, who's the victim. He says, can't see that name on the phone, because she's my things. And then in the next call, the defendant gets her added to the call. He calls the third party who then connects her to the call, and they're talking. And I also have concerns that he would be contacting her at a different number because I had a note from Detective Mosher that he had been contacting her as well as a different number. I'm just not sure exactly what that number is. And given the facts of this case, I'm extremely concerned.
And may I address all those issues, Your Honor?
Yes.
And so briefly, Judge, my client
Just so that I know, currently right now, he was ordered on a tether and he's not on a tether right now.
Absolutely not, Judge, and I'll address it. So Judge, if I may, so Mr. Hankey's 22 years old, Judge, has no criminal history whatsoever. This is his first ever contact with the law. Literally, Judge, 3 days ago, he admittingly cut his tether off. He got overwhelmingly scared. He didn't understand what he was actually charged with. He thought he was charged with a life offense. I told him, no, it's a felonious assault. He was under the impression that he was immediately going to prison today because he didn't understand the law. And so he freaked out, Judge, and he indeed, admittingly, he cut his tether off. I immediately spoke with my client. I told him not to run, not to go anywhere, to address the court and to be upfront about it. And so, Judge, he's here today. He had every opportunity to not be here today, every opportunity to run, and he didn't. He takes full ownership for cutting that tether off, Judge. If I had talked to him before he did it, I don't think it would have ever happened. But Judge, I don't think he did it intentionally to, flee from the court. I believe he did it, honestly, Judge. And if hear me out, Judge, I think this is a situation, Your Honor, where fear got the best of him, anxiety got the best of him. In terms of the jail calls, Your Honor, I would
Do
just
we
make
have the tether back?
Your Honor, I'm not sure, but I did also want to address that the defendant does have a juvenile adjudication for a CSE fourth and a dismissed DV from 2022, which the victim failed to appear as well.
Judge,
Go ahead.
community corrections have the tether back, and there's been communications with the tether agent and the office. And so, Judge, in terms of the jail calls, I was just made aware of those this morning. I would note that his the complainant in this case is his girlfriend. She's currently pregnant. I told my client to have absolutely no contact with her whatsoever per the bond conditions. And so, Judge, I make this argument, Your Honor, because honestly, I'm asking the court if they would give him a second chance. It was a $70,000 cash surety bond. That bond was posted. But for his actions 3 days ago, Judge, we wouldn't have this bond violation, at least with the tether. With the phone calls, Judge, again, I'm not saying he admits or denies that, but he knows he's not to have any contact, third-party contact with the complainant, and that will continue. And so, Judge, I'm asking if my client could have a second chance on this tether. Again, Judge, he could have been like everyone else and just not come back or got caught.
We would have got him. I mean,
and you stole the words out of my mouth, Judge. I said, or he could be standing here today in a green jumpsuit, and he's not. He's here today, Judge, fully accountable for his actions. It won't happen again, Judge. I guarantee it. We plan to address this case. I'm just asking for a second chance.
Counsel, go ahead. Anything?
I just would kind of reiterate the facts of this case in which he pointed an AR-15 style rifle at the victim, saying to her, "I'm going to kill you. I'll put a bullet in your head." And on the phone call, he addresses that he knows he's not supposed to be talking with her because when the other person says, "Kia, who is the victim?" he goes, "Don't mention her. She's my case." So I have great concerns that he would still be violent.
We're playing the game. I don't play games. We don't play games here. You don't get to be put on a tether. Well, first of all, be told that you should not be contacting the victim and then finding and manipulating ways to do so. Don't do it here. Doesn't happen. Won't happen. And then when you get the grace, given the nature of the charges, to get let out, then you're running around and you decide that what the court ordered in terms of a tether, you decide you want to cut it off yourself. We don't do that either. Defendant's bond is revoked. Defendant's remanded. I'll see him on the 13th. And counsel, you can give me your argument as to what I should do with his bond at that point. But right now, he's remanded.
Thank you, Judge.
Thank you.
And there it is, the breaking point. After hearing every excuse, the judge has had enough. His message is clear. You don't get to play games with the court. The moment Maris cut off that tether and tried to contact the victim, his second chance vanished. The law doesn't bend for fear. And in this courtroom, accountability always wins. This case is a powerful reminder that leniency isn't a guarantee. It's earned through responsibility. Whether it's fear or arrogance, breaking bond terms almost always leads to one outcome: jail. If you found this case as shocking as we did, hit that like button, share your thoughts below, and subscribe to Courtroom Authority for more jaw-dropping real-life courtroom moments, shocking rulings, and judge reactions that define justice in action.